Now to our second keynote speaker this morning, the Honourable Jennifer Coate, AO. Justice Coate is a former judge of the Family Court of Australia, and she served as Commissioner on the 5-year Royal Commission into Institutional Responses to Child Abuse. Prior to that, she held a number of appointments, including Judge of the County Court of Victoria, State Coroner of Victoria, the inaugural President of the Children's Court of Victoria, Senior Magistrate of the Children's Court of Victoria, Magistrate and Deputy Chief Magistrate of the Magistrates Court of Victoria. Justice Coate has also worked as a part-time Law Reform Commissioner, a solicitor in private practice, a solicitor for the Legal Aid Commission of Victoria, and in policy and research for the Victorian Government. In 2019, she was awarded an Order of Australia and became an officer of the Order of Australia. And she's someone I've had the great fortune to work with over a number of years in my career, and we both share a great passion for the protection and safety and well-being of vulnerable children. Please join me in welcoming Justice Coate.
Thank you, Jill, for that welcome and introduction. I do sometimes worry about that introduction because it does sound a little bit like I can't hold down a job. Thank you for the opportunity given to me this morning to present to you, but before I commence, I would like also to join with the others in acknowledging the traditional owners of the land upon which we meet, and I pay my respects to all elders past, present and emerging, and extend particular respect to any Aboriginal or Torres Strait Islander people present with us this morning. So the Royal Commission into Institutional Responses to Child Sexual Abuse was established, as many of you would know, by the federal government at the end of 2012. And it was established in response to allegations of sexual abuse of children in Australian contexts over many years. Our work was an examination of a range of institutions in which children were sexually abused, but it was also an examination of allegations of widespread institutional failures and practices that provided cover and protection to perpetrators, either inadvertently or intentionally, and in many cases failed to respond appropriately, if at all, once aware of such abuse. Some of the institutional characteristics that increase the risk of child sexual abuse are clearly specific to sexual offending against children. But you may consider that other aspects or institutional characteristics will be applicable as risk factors for potential institutional wrongdoing more generally. And similarly, you may consider, as I go through the presentation, that some of the features of the institutions that failed to respond adequately or at all, or engaged in protecting the institution against public exposure, are applicable to institutional wrongdoing more generally. Similarly, you may consider that some of the features of the institutions that hampered disclosures of abuse and failed to respond adequately or at all, or engaged in protecting institutions against public exposure, again, are applicable to institutional wrongdoing more generally. So institution, for the purposes of this Royal Commission, were described, or defined rather, in the letters patent in broad terms, and the definition included any public or private body or entity that provides or did provide services or facilities to children. So this definition resulted in us receiving accounts of child sexual abuse in a broad range of institution types that ranged from schools, both day schools and boarding schools, independent and government-run schools, religious institutions from church and of course school settings, to a wide range of religious-based activity, orphanages as they were referred to in earlier years, and out-of-home care facilities in more contemporary environments, recreation and hobby clubs such as scouts, dance academies and sporting clubs, youth detention facilities, childcare facilities and programs, Australian Defence Forces, and a range of hospital and health settings. Indeed, over the 5 years of this commission, we received reports of child sexual abuse against over 4,000 institutions across our nation. So given the nature of this conference, I thought it may be of interest to say something about how we went about our work. It also gives an understanding of the basis upon which we arrived at findings and recommendations. So we informed ourselves in 3 main ways, sometimes referred to as the pillars under which we did our work: private sessions, public hearings, and a policy and research program. So something about private sessions. Importantly, prior to the commencement of the private sessions part of our work, an amendment was made to the Commonwealth Royal Commissions Act, setting out what attendees said in these sessions was information and not evidence, to ensure that people who wished to approach the Commission confidentially could do so. There was contained in the amendment an obligation to tell the truth. But the identities of and the information provided by people in private sessions was protected in this way unless the attendee himself or herself subsequently agreed to give evidence at a public hearing, in which case, of course, a formal statement was made and then distributed to the interested parties with leave to appear in that public hearing. Private sessions were arranged as a result of people making contact with the Commission and seeking to have their stories heard. So there was no sense that the Commission was engaged in seeking out people. One-on-one sessions with a commissioner and a legal officer in the room enabled the attendee to speak in a confidential and supported environment to give their account of what happened. People were often anxious that they didn't have specific memories of in what place they were in, what date, what time, and they were very relieved to hear that this was not a necessary part of any requirement in private sessions. In fact, the private session took its shape from the person who was attending to give their account to the Commission. I've got a slide prepared for you because the figures tell a story in and of themselves. So during the 5 years of our commission, you can see there the second dot point tells you that we held 8,013 private sessions over that 5-year period, conducted amongst the 6 of us commissioners. You can see that we held private sessions not only in every capital city, but went into 25 regional locations. And I do draw your attention to that bottom dot point, commissioners went into 62 correctional facilities. Indeed, over 700 of those 8,013 private sessions were held inside correctional facilities, which says something about the people and their backgrounds inside our correctional facilities. We also allowed people to provide written accounts to us for those people who, for a range of reasons, did not want to come personally into the Commission or were not able to. We referred over 2,500 matters to police using the statutory powers inside the Royal Commission Act. Generally, people were reporting to us that they had reported matters over the years. Some had reported matters, some hadn't, to police, many of which had not been acted upon. But just over 10% of the reports that people gave to us in those private sessions indeed were first reports. In other words, the first time the attendee had ever given any information about what had happened to them inside their institution. So as well as being a fundamental source of information to the Commission, there has also been considerable positive feedback about the value of these sessions for attendees. It was regularly reported back to the Commission from numbers of attendees at these sessions that they felt finally acknowledged and validated. Many also said that they valued the opportunity to tell their story to help protect not only the children of today, but to make the nation a safer place for all children via their contribution to the Royal Commission. So our public hearing work, which of course is much better known, certainly inside Australia, had us conducting 57 public hearings, and of course our public hearing room looked fairly much like any form of traditional public hearing, including a courtroom. Importantly, the 57 public hearings that we conducted were live streamed, and they were live streamed not just across the nation, but they were often being watched from international locations. Our information technology people were able to report to us to tell us what international locations were logging on to the public hearings. So what we came to understand was public hearings, in particular into religious institutions such as the Catholic Church, the Salvation Army, Jehovah's Witnesses, and the Yeshiva case study, attracted substantial audiences from international locations. So much of what became the subject matter of those public hearings emerged from patterns of information coming out of private sessions, put together with the general criteria that we settled upon to ensure a geographical spread, an institution-type spread, and of course always consistent with what we were hearing in private sessions, and illustrative too of systemic issues that were repeating themselves from the private session information that we were hearing. So apart from the obvious value of the public hearing process, it regularly elicited during the course of the public hearing not only more information about the institution being examined, but a range of other information about other institutions relevant to our terms of reference. And further, people were reporting to us in private sessions that they had been motivated to come forward by watching others courageously give evidence publicly. Sometimes this was as a result of media reporting, or sometimes it was as a result of people telling us that they had been watching the live streaming. It became clear also that the public hearings provided general community-wide awareness raising about child sexual abuse in institutions, contributing to making these institutions safer places for children via that public awareness raising. So the policy and research program, in order to make recommendations, we obviously needed to understand more about a range of issues. And to this end, a program of research was established to answer some key questions and to respond to gaps in both the Australian and indeed the international database. So we used an in-house policy team and in-house research experts who oversaw and guided this part of our work. They assisted in engaging with a number of academics across a range of universities where we commissioned work to provide relevant pieces of research to us, and this resulted in the publication of 59 separate research reports that are all available currently still online at the Royal Commission website. In the course of that policy and research work, we held a number of both public and private forums and roundtables on a range of topics. And we also called in panels of experts in the final stages of our public hearings. That policy and research program assisted across every aspect of our work, including the provision of a range of analysed data to enable institutional patterns and systemic issues to be included in our reports. So we provided our final 17-volume report in December of 2017, and we'd already provided 3 other reports prior to that: the Working with Children Check report, Civil Justice and Redress report, and the Criminal Justice report. In total, across all of those reports, we made over 400 recommendations directed at governments and institutions. And I thought it may be of value to take you through just a little bit of that data, always better in PowerPoint presentations. So an example of the de-identified data from private sessions is contained in this next slide. So I'm going to draw your attention to 3 institution types. The first, which formed, as you can see, 41.1% of reports made to us in private sessions, was the out-of-home care institution type. And those figures, as you can see, are divided into pre-1990 and post-1990. The next most significant group of institution types were schools. So, in other words, just on 1/3 of all reports being made to us in private sessions came out of schools. And the combination, that next religious activities description covers a range of religious type activities, including attendance at faith-based institutions, camps and other youth type activities for those faith-based groups. And the figures start to diminish as you go down that list. I say that with absolute respect to the individuals, of course, who attended, because each one of those figures, as you can see in the column headed number, is an individual person telling us their account of what happened to them in that institution. So a further analysis of the information resulted in data which also showed us a different breakdown across those institution types. And there it is. 58.1% of all survivors attending private sessions said that the abuse took place in an institution managed by a religious organisation. 32.5% in a government-run institution and 10.5% in a non-government, non-religious run institution. So that 58.1% that told us that they were abused in a religious setting included, of course, if you recall the previous slide about out-of-home care and schools and other institution types, that accounts for that 58.1%, so out-of-home care and schools or other religious activities. So the abuse that occurred in religious schools, orphanages, missions, churches, presbyteries, rectories, confessionals, and various other settings. It accounted for over 4,000 people. Of that group, the 58.1% who told us that they were reported in an institution managed by a religious organisation, our analysts did further work in breaking down as inside the religious or faith-based organisations. And there's the graph that's been published already, of course, by the Royal Commission. And you can see, again, by starting at the top of that graph, that of the 58.1% reported in religious institutions, 61.4% came from Catholic groups, 14.8% Anglican, and 7.2% Salvation Army. Harking back to the schools setting, you'll recall that 31.6% in schools. 71.8% of those school settings reported to us were in religious school settings. Now, of course, the failures weren't confined to religious institutions. However, the failures of religious institutions are particularly troubling because these institutions have played and continue to play an integral and unique role in the lives of many children in our nation. They've been key providers of education, of health and social welfare services to children in Australia for many years, and they've been among the most respected institutions in our society. The perpetrators of child sexual abuse in religious institutions were, in many cases, people that children and their parents trusted the most and suspected the least. The next slide I want to show you as a backdrop to what else I want to say is a breakdown of the role of perpetrators, and by that I mean people who weren't necessarily convicted but who were the subject of the reports that came to us in private sessions. So you can see again at the top of the list that 32% told us they were abused by a person in religious ministry, 30.1% told us they were abused by a teacher, and 13.7% said they were abused by a residential care worker, and then a range of other reports that covered foster carers, dorm masters, house masters, custodial staff in detention facilities, medical practitioners in both public and private settings, volunteers across all institutional settings, youth group leaders, sporting coaches, and of course a range of other roles. So these figures that I've shown you that have been published by the Royal Commission, these figures resulted in us conducting 30 public hearings into religious institutions and dedicating 3 volumes of the final report to religious-based institutions. We made a range of findings and recommendations about the risks in specific religious institutions. We made a range of findings and recommendations about the risks in schools, in sporting and recreation facilities, in residential care, in other forms of out-of-home care, such as boarding schools, in detention facilities. So all of these institutions have unique features and cultures and governance structures that pose risks for children and barriers to reporting and disclosure. But for today's purposes, I've endeavoured to extract some of the more universal themes that we found across institutions that increase the risk that child sexual abuse will go undetected and, or, if reported, not responded to in any appropriate way. However, because the numbers which emerged from the religious-based institutions, as you can see, as they emerged, I'm going to turn first to the systemic issues that we found in this context. And I have headed this slide, Common Responses from Religious Institutions to common factors, really, that contributed to inadequate responses. I've put it into a slide because I thought it was perhaps a little bit too wordy to present to you just orally without that visual picture. So I don't think any of this will come to you as a surprise, that structure and governance, limiting accountability and adopting in-house responses, internal, secretive and closed responses were recurring features of common responses from religious institutions. Again, the systemic issues which emerged in particular in the case studies were cultures that demanded loyalty and obedience, and a protection of the institution, which of course in turn required protection of individuals who were the subject of complaints. We heard regularly, in particular inside the Catholic-based institutions that we examined, that child sexual abuse was seen by many as what was described to us as a moral failing, or rather or perhaps even at times described to us as a spiritual lapse rather than a crime. And of course, protecting perpetrators rather than children, protecting the keepers of the institution was another systemic recurring feature, as was the application only of religious laws or principles, or primarily of those religious laws or principles, and a preoccupation, as I've already said, with protecting reputation and status. It goes without saying that many of these faith-based institutions that were examined were what might be described as quite closed institutions, and many had little or no female presence in any management positions, supervisory or positions of any power. So we've developed, as I said, a comprehensive set of recommendations aimed at making religious institutions safer for children. Many of the recommendations apply to all religious institutions in Australia. Some are specific to particular religious institutions, and we did that because there were dangers of particular structures, practices, or theological beliefs which emerged systemically, and these are reflected in our recommendations. In some cases, you will see that our recommendations are also relevant to the international leadership of religious organisations. In some religious institutions, theological and scriptural beliefs and practices that reinforce the superiority of its religious leaders make them beyond reproach. Further, and in some faiths, those theological beliefs were supported by the notion that the faith-based institution was not otherwise accountable to the civil or state authorities. We examined these matters to the extent that they have affected and may continue to affect the vulnerability of children to abuse and the likelihood of religious institutions responding poorly when that abuse occurs. Leaders of religious institutions were also often reluctant to remove alleged perpetrators of child sexual abuse from positions in ministry or employment after suspicions of child sexual abuse were raised or allegations were received. In some cases, we found that perpetrators made admissions of behaviour amounting to child sexual abuse, yet religious leaders were still reluctant to take decisive action or report them to police. Across religious institutions, the inadequacy of internal disciplinary systems and the limited use of disciplinary measures meant that some perpetrators of child sexual abuse were not disciplined at all. Some were disciplined but in a minimal way, and others were disciplined but only after many years after allegations were raised or indeed they were convicted. This often meant that perpetrators who were in religious ministry retained their religious titles, and lay perpetrators remained attached to religious institutions in circumstances where it was plainly inappropriate for them to do so. Instead of reporting allegations to police or engaging with formal disciplinary processes for the dismissal of perpetrators, people who responded to allegations of child sexual abuse in religious institutions sometimes encouraged perpetrators to retire or resign as a way of dealing with these matters, in inverted commas, quietly. Some leaders of religious institutions also took steps to conceal the real reasons for which people were removed from positions in ministry or employment following allegations or admissions. And this included, for example, allowing perpetrators to retire or resign on false grounds or grounds not made public, such as for health reasons. So turning more generally now to the gaps and failures across all institutions, I want to have a look at an examination of the barriers to reporting and to disclosures. And I've broken these down into barriers to victims, survivors reporting, and barriers to adults inside institutions reporting, because both of these, of course, are crucial factors in understanding what happened, but they're also crucial factors in our considerations about the recommendations needed to address the barriers and enhance reporting. So, and I do that in the backdrop, I should say, of telling you that our figures with respect to delayed reporting for victims was 23.9 years. So averaged across those 8,013 private sessions, the time from offending to first report was 23.9 years. Split gender-wise, women were around about the 20 years and men were around about 25 years. So what were the main barriers that were reported to us in private sessions that stopped people from reporting? I don't think any of this list will come as any particular surprise to most people in the room, but it is worth reminding ourselves what's contained in that list. Shame, embarrassment and guilt, there you can see at the top of that list. And that shame, embarrassment and guilt lasted not just during childhood or adolescence, but clearly well into adulthood. Almost 30% told us they had no one to disclose to. So this of course is the children and young people saying that inside the institution they felt they had no one they could trust, no one to disclose to. And it's worth pausing for a moment to think about the huge numbers of Aboriginal children removed from family, culture and country who certainly featured quite heavily in the Royal Commission. 26% said they feared not being believed. And a further examination of that group, the 26.3% who said they feared not being believed, often explained to us in private sessions that they feared not being believed because they could hardly believe it themselves, what had happened to them. But they also indicated that sometimes the delay itself caused them to think, even as they moved into adulthood, that the longer I delay, the less likely I am to be believed. And that considerable figure at the bottom of those who told us they feared retribution generally were reporting they feared ostracism, physical punishment, but also some were of course reporting that they were being directly told that they would be punished if they told anybody about what had happened. So the failures of organisational culture, governance structures, and a lack of any independent oversight, a lack of policies and procedures for complaint handling were also all repeated themes in the analysis of the evidence from public hearings. So clearly our work found widespread non-reporting or non-effective reporting amongst adults in many of these institutions too. And that's worth very much in this context thinking about. So I'm going to put to one side our findings of active and intentional obfuscation or the willful disregard for the safety and well-being of children. The barriers and inhibitors to disclosure from both the research and the evidence speak volumes about culture, but equally so does the data about why adults working in and living in these institutions didn't report. There was often an interplay of institutional and individual factors which played a role in inhibiting adults from reporting. Now, I have put together a slide for this, but it's way too busy and too distracting, so I'm going to use the old-fashioned method of just reading it to you. The themes that emerged, so I'm talking about the themes that emerged from our case studies about adults who were examined in the course of public hearings, about why they didn't report. So a range of fears and concerns emerged, which often led to those adults reframing, minimising, reinterpreting what was being said. And it was often done to avoid having to conclude that any sort of report or action was required. And I've got examples from some of the case studies. Case study 6 and case study 18 were examples of that. Uncertainty about identifying suspicious behaviour, often ambiguous behaviour, and the case studies were littered with examples of this. Perpetrators, witnesses indicated that they too felt groomed or manipulated by the individuals who later became the subject of complaints. So they actually gave evidence that they understood now that they were slow to see or understand or believe what they were seeing or hearing. We heard evidence of a fear of a range of possible negative consequences for self, such as I might have to go to court, I might have to cause a colleague to lose a job, I might lose my own job, I might experience rejection or ostracism in the workplace or the community. Maybe I'll be making a false report and I personally will be held liable. And all of these fears were magnified if the suspect was a highly regarded person in the institution or had some particular qualities valued by the institution. So again, putting to one side willful and calculating instances of cover-ups, witnesses reported considerable anxiety and uncertainty, and that they felt ill-equipped to interpret what they were observing. Institutions which prioritised reputation over the care and safety of children obviously created their own inhibitors and barriers, and in a number of cases, both victims and adults working inside the institutions told us they felt unable to disclose due to the prestigious nature of the institution, or indeed the institution's emphasis itself on reputation. Again, just expressing that in a different way, there was evidence of people fearing disruption to valued relationships. I think that was referred to in Professor Clickard's presentation. They feared they would suffer recriminations and shunning. People also reported disbelief and shock at the prospect that a colleague may have perpetrated child sexual abuse. And some people reported that they didn't have confidence that anything would happen. So let me turn to some more general systemic or repeat patterns of institution types and features that produce significant numbers of reports of child sexual abuse. We grouped together what we call total institutions in terms of drawing some systemic features out of those institutions. And the features of these institutions are where members are sharply delineated into those with power and control and those with lesser status. Features of total institutions that assist in the perpetration or prevent the detection of child sexual abuse include the tendency of total institutions to constitute an alternative moral universe, often with high regard and status for those in positions of power within the institution who are considered beyond reproach. Some total institutions extinguish the pre-institutional identity of the powerless, and most often, of course, the powerless that we're talking about are children and young people. They embrace degrading assumptions about the nature of the powerless and withhold information about the institution's operation to the outside world. Some examples of some of these institutions, total institutions, were the Defence Forces, orphanages, youth detention facilities, and some closed religions that limited contact with the outside world. We also heard a considerable amount about institutional cultures which normalised physical abuse, bullying, including physical aggression, verbal aggression, and the use of sexualised language. These sorts of features were in institutions with high rates of complaints of offending against children. Another repeat feature across all institution types was a lack of any effective, accessible system to make a complaint. So our case studies revealed numerous instances where institutions simply had no accessible system to make a complaint. And given what was revealed about the wide range of barriers to reporting, both for children and adults, this obviously makes for potent danger. Non-existent, inconsistent, ill-informed investigations were also a feature of the systemic issues that emerged in case studies, together with poor investigation standards, which didn't assess and manage risk to the ongoing safety of children. The lack of inconsistent and accountable complaint handling systems meant it was common for institutions to respond to allegations or disclosures by dismissing or denying the allegations, punishing the victims, minimising, reinterpreting, reframing the complaint, failing to report to police, or adopting in-house responses guided by internal policies, or, as I've said, in religious institutions, religious laws and principles. Another common recurring feature was a lack of any independent oversight of a range of institutions that sought to handle reports and complaints internally and avoid ramifications for the person accused and the institution. We found that independent oversight of institutional complaint handling can improve identification and reporting. It can improve the capacity of the institution to handle complaints, and it can strengthen the institution's accountability for and transparency in the way in which it responds to complaints, obviously always with the ultimate aim of making those institutions safer places for children. In Australia, the only model of independent oversight of institutional responses to complaints of child abuse and neglect across multiple sectors is known as the Reportable Conduct Scheme. These schemes oblige heads of institutions to notify an oversight body of any reportable allegation, obviously defined within the terms of the scheme, reportable allegation, conduct, or indeed conviction involving any of the institution's employees, and provide for the oversight body to monitor the way the institution investigates and handles allegations. For any of you interested in having a look at that in more detail, you can go to volume 7 of the Commission's report, and we certainly recommended that all state and territory governments establish nationally consistent reportable conduct schemes that include religious institutions. Another systemic feature was no codes of conduct. Codes of conduct that set out what is and is not acceptable behaviour. We concluded that codes of conduct play an important role in setting standards for acceptable and unacceptable behaviour, and identify behaviour that meets the threshold to warrant a complaint being made. Given our findings about why adults, meaning adults in workplaces as opposed to adult survivors, don't report their suspicions or concerns, and the often secretive and sometimes ambiguous nature of an offender's behaviour, a code of conduct that sets out the behaviour by adults towards children that the institution considers unacceptable makes clear what needs to be reported. I should hasten to say that those rules or policies or procedures need to be public. We've recommended that they are publicly accessible, clear and enforced. Indeed, in one of the very early case studies we did into the YMCA, a case that was where the YMCA were running a childcare facility, the offender ultimately convicted was acting in breach of the babysitting rule, as it was called, inside the YMCA program, which prohibited any employees from taking babysitting jobs as a result of the families who were connected to the childcare facility. This offender was indeed doing that, but the case study revealed that the rule itself was being regularly flouted, including by the offender's manager. Education, training and communication of policies got considerable attention from us. Given our findings about both personal and institutional barriers inhibiting disclosure, the absence of education, training, communication, importantly support and guidance about policies and codes of conduct, reporting obligations, both mandatory and voluntary. An absence of education, training and communication of this nature will increase the risk of harbouring unreported abuse. We also found record keeping and information sharing was another systemic feature where institutions had no appropriate record keeping or methods to share information in a timely and effective manner. And in some cases, this meant that perpetrators were able to continue their involvement inside the institution. A quick word about pre-employment screening practices. And these were findings from the research that the potential that I thought I would share with you today, the potential deterrent effect of comprehensive pre-employment screening practices, the research found, may never be able to be quantified, but shouldn't be disregarded solely for that reason. The literature suggests that when combined with other policies and practices that promote a positive organisational culture, comprehensive pre-employment screening practices and comprehensive are likely to contribute to safeguarding children in these circumstances. Excuse me. Obviously, a fundamental part of the work of the Commission was to make recommendations to better protect children in the future. And we commissioned research which examined the extent to which recommendations of previous inquiries had been implemented. And we asked those researchers to look at the factors that affected implementation. In other words, what made those recommendations more likely to be implemented and what made them less likely. That research, for those of you who are interested, is published on our website. That is, as I said, still existing. It was by the Parenting Research Centre to evaluate that very issue. They looked at 288 recommendations from 67 previous inquiries of relevance to the terms of reference of our Royal Commission, and found, amongst other things, that structural constraints and cross-jurisdictional differences needed to be very carefully managed. Recommendations needed to be drafted with sufficient specificity and flexibility, hard to say and hard to do, Recommendations focused on outcomes rather than activity, otherwise they can intentionally fail to address the real drivers of the problem and not bring about systems change. And to bear in mind that over-regulation can foster a culture of compliance rather than cultural change. And finally, we also included recommendations directed to ongoing public reporting to ensure the public's capacity to track responses to the Commission's recommendations. And I'll just put that last slide up, to demonstrate to you that we made recommendations about ensuring that there was public responses that people could follow. So I appreciate that much of this can be difficult to listen to and even more difficult to comprehend. The Royal Commission provided the opportunity to tell the national story of children, sexual abuse and institutions. Some have been concerned and have expressed the view that it's opened Pandora's box. In response to that, I say, remember what was left in Pandora's box after all of the evils of the world flew out. Hope. The one thing left in the box was hope. And I hope that with this Royal Commission, we can lay the foundations for a new national story, one that provides a safer future for children in our nation. Thank you.
Thank you, Justice Coate, for a really illuminating case study. It is a shocking example of systemic corruption and failure with terrible life consequences for many people. But there is so much in that Royal Commission that we can learn and adapt for the work that we are doing now in the public sector. And it's salutary to think about how we'll be judged in the future for the work that we're doing and whether we're able to, at the very least, prevent systemic events on such an extraordinary scale as we saw uncovered in the Royal Commission, and not just in Australia. We've seen these examples worldwide. So please join me in thanking Justice Coate.